The word on the street definitely was, we're going to try and get this through before we rise for summer. It got bogged down in the House of Lords. You might have anticipated that, given how important and how radical some of these proposed changes are. I still think Labour suffers from this delusion that you're only in proper employment if you're working 5 days a week, 8 hours a day, and anything other than that is not proper employment. Well, you and I know that the real world is very different.
Hi, and welcome back to Orca Pods. I am delighted to once again be joined by Paul Chamberlain. We sort of alluded to this in our first episode that we recorded together, didn't we? That we were going to make this almost a mini-series, such as the importance of the Employment Rights Bill. And also, I have to be honest, the success of the first episode, you are officially the highest viewed Orca Pod guest and subject matter.
Wow.
So
I don't know what to say.
Well, listen, look, I think we're all aware now that and the penny's dropping the importance of this. And I think obviously what we're going to discuss today is in essence just going to lend itself to how governments move forward, the announcement of the roadmap, which is going to be fundamentally what we're going to talk about today. Yeah. But I think just fact is, and I had a lot of feedback from people who listened to say how informative it was. So yeah, delighted to.
Good, no pressure then.
Well,
no pressure.
When you're as skilled as you are, so I don't worry about pressure for you. So look, I think. Do you want to give us an overview in terms of where we were? Yeah. I know in the first episode there was a slight theory that the Employment Rights Bill was potentially going to reach Royal Assent before government, or before Parliament, sorry. What's the official term?
Recess. Summer recess, yeah.
Yeah. That didn't happen, did it? So
No, it didn't. And I think it took a few of us by surprise. The word on the street definitely was, we're going to try and get this through before we rise for summer. It got bogged down. I don't think there's any other way to describe it. It got bogged down in the House of Lords. I suppose you might have anticipated that, given how important and how radical some of these proposed changes are. And, that's what the House of Lords is there to do, to scrutinise, to take it apart, to put it back together again, to make recommendations as to how it might look better, how it might operate better. And that's really what happened. So basically the House of Lords ran out of time and they'd proposed quite a few amendments. So we didn't get Royal Assent before the summer recess. Again, the word on the street is that the government are aiming for Royal Assent not long after we get back in September, October time. We'll have to see, but that's what they would like to do. Where it was left just before summer was at third reading in the House of Lords. And as I say, some amendments proposed. But as we were discussing before we started recording, I'm not sure most of those amendments are going to see the light of day because they are radically changing what was originally proposed. And the one we discussed, you might remember, was the day one rights around unfair dismissal. So the House of Lords have proposed an amendment to that. They think, as do I, that giving people unfair dismissal protection from the minute they start is too onerous for employers. So the House of Lords amendment that was passed was to reduce the qualifying period from 2 years down to 6 months.
You don't think that's...
Well, I think that makes sense.
I agree.
I think that makes sense. Yeah. 2 years down to 6 months is still a significant change, but it isn't as significant as reducing it down to 0. I think it's fairer on employers, but my concern is that the government are likely to say, well, it was a manifesto commitment to give employees rights from day one. So actually, if we reduce that qualifying period to 6 months, we're not delivering on that manifesto commitment. So I don't think that amendment will see the light of day. But, never say never. There might be some other compromise that the government are considering. I personally think they'll stick to their guns and say unfair dismissal protection from day one.
And I think it's certainly from where I sit, with the roadmap then being announced. Can't believe I'm going to say this. I came across a bit anti-Labour last time, and that wasn't my intention. But it actually sounds like with the roadmap that credit where credit's due, they've listened to business, and have actually thought, okay, well, the potential to just literally drop all of this in one hit, I don't know whether catastrophic would be the right word. It'd certainly be enormously difficult and problematic for business.
I mean, they've definitely reflected. And I know we're going to come on to talk about some of the consultations that they've announced. But if you want my political take on it, I think they were having such a rough ride a few months ago with everything else. The economy was tanking. There was a lot of bad feedback around national insurance hikes, no growth. Pretty bad news for Rachel Reeves in the round. And I think they've probably taken the view that they run the risk of putting the economy even further back if they rush a lot of these changes in. Now, they're not selling it in those terms. What they're saying is, we always knew that a lot of these provisions would need to be considered in detail and finessed so that we get it absolutely right. And I think the emphasis on some of the consultations that they've put in the roadmap lends weight to that. So, we're going to have some consultations. And then, as you say, the roadmap that was fairly recently published says that implementation of the final provisions will be staged over a period running from, effectively some easy wins before the end of this year, assuming we get Royal Assent in the autumn, through to 2027. So at that point, we're going to be 3 years into a Labour government, and we may still not have all of this employment rights bill. And remember, it was promised within 100 days.
Yeah.
So it's a little bit odd for me that they dashed to publish something within 100 days that they'd set themselves, which was an artificial deadline, then only to have the really difficult provisions brought in 3 years later.
It's probably, again, relevant to say this. So what we did in the first podcast was we framed a lot of this around industries that you and I, the bulk of our work is in, which is recruitment agencies. And we're going to do the same again today. That's not to obviously be dismissive of any other business out there, but obviously just trying to keep it on the same trajectory and path. Consequentially then, for something that was... the aim was to bring it in pretty quickly, to now have a more stagnated approach. There's obviously pros and cons to that. But if I'm a recruitment agency right now sitting here listening to this, from our first conversation and episode to now, what do you think is primarily, I don't know, the best path to go on? Is it just preparation? Is it as simple as that?
Well, I think I maybe preface my reply by reminding everybody that, of course, the bill itself didn't have everything in it. So you might remember when it was published, there was a document that came alongside it that was called Next Steps, which was quite a full document, and it had things in it that had been promised in the manifesto, but which the government clearly took the view was going to be much more difficult for them. So, for example, getting rid of worker status, maybe I should rephrase that, not having 3 employment statuses, which we've got now. So employee, worker and self-employed, and effectively merging worker and employees together by dragging up workers' rights to the same level as employees. And I think we talked very briefly about this last time. That is terribly difficult. I mean, if you say it quickly, it sounds really easy, but conceptually and from a detail perspective, it's really difficult. All sorts of ramifications. Lots of legislation would need to be altered as a result of that. Massive additional costs for employers. So all of that was put to one side, and there is, given that this bill, as and when it becomes an act, is going to have staggered implementation over a 2.5-3 year period. Goodness only knows when we're going to get to the stuff that's in the next steps document. Maybe we never get there.
Right.
So in that sense, you could argue this is a bit half-baked. And I know I've not answered your question because you were looking at what should recruiters do. I suppose to some extent, recruiters and employers generally, they maybe can breathe a bit of a sigh of relief, in the sense that they've got a bit longer to prepare. But are you able to say to them, do you know what, when we did our first podcast, these things over here you don't need to worry about? No, we still need to worry about them. It's just that we've got a bit longer to worry about them, or depending on which side of the political persuasion or line you're on, longer to prepare for them.
And I think that terminology is the one that I would use. And I think your point about economic uncertainty, I'm seeing it in the news, tax rises and the next budget isn't far off. I think preparation is certainly the key part. And I think you're right. I think what it does allow employers very much is actually a deep breath to actually be able to, and even for me and my business, my shoulders were able to relax a little bit. There's been a hell of a lot that UK business has had to take on. Whether that be economically with the national insurance increases, the employment rights bill. I've spoken to people who feel like they were genuinely being suffocated, and it's how much more. And actually then when the announcement came that there would be a stagnated approach, what, credit where credit's due sometimes.
Yeah, and look, I'm not expecting anybody to spare a thought for the advisors, the lawyers. We've breathed a sigh of relief too,
right, okay,
because the more we've looked at these provisions and the prospect of all of them coming in within a relatively short time frame, the more we've realised how much work we need to do to make sure that clients are aware. And, we've got to provide advice on all of this. So we've got to get up to speed with it. I think I am with you going to give credit to them for slowing things down.
Yeah,
and what I hope is that the consultations that they've announced are genuine and effective. There's little point in going through the motions in a consultation if you're not willing to listen and change your approach. I appreciate that in principle things will stay broadly as they are.
Yeah.
But the detail around all of that, I think if you're going to go out to consultation, you've got to be prepared for the responses and the results, and you've got to be minded, or at least open to modify the proposals as a consequence.
Yeah, and do you know what? Sorry, I've literally this is my first time using technology in one of my podcasts. I'm trying to get down.
My technology is a sheet of A4 paper.
See,
down
I'm
there,
the same, but my wife kept digging me out about my bright red file, so I've got my iPad. But I've actually, so you were talking about the consultations there. So I've got the published roadmap in front of me, and I'm looking at the phasing consultation piece now. So summer, autumn 2025 consultations. What part do you think is relevant for us to talk about today?
Well, the one that jumps off the page there is the day one rights around unfair dismissal. So that will link in nicely with the Lord's Amendment, whether that passes or it fails, what the government's approach to it will be. I'm not a betting man, but if I were, I would put a small wager on that not changing. That is going to remain, I think, as it is. There may be some changes around the statutory probationary period, which we talked about last time, because my understanding is the day one rights for unfair dismissal will come with a bit of a sop to employers, which effectively says, as we explained last time, during a period of time after someone starts, it will be a little bit easier for you to dismiss someone fairly than it would be otherwise. So and that's the statutory probationary period that we're talking about. So it might be that the compromise there is, do you know what, we're going to leave it as day one, but we might extend the statutory consultation period beyond the sorts of numbers that we were considering last time. And it was 6 months. I think there was a debate internally within government as to whether it should be 9 months. I think they landed on 6.
Okay.
But that could go north again, couldn't it? It could go to 9 months. It could even go to 12 months. And they might decide that's an appropriate concession. But I think in terms of the imminent consultations, that's the one I'm really interested in.
Mm-hmm. And in terms of, so obviously the consultation's done, how much heads up would we get so that we can prepare for that? So again, if I'm a business right now thinking, okay, I'm going to keep my ears pinned back for this.
Yeah, well, look, I mean, we subscribe to services that alert us to things like this.
Yeah.
I appreciate that most employers won't have the benefit of those. So it's just keeping an eye on the government website. The relevant departments will set out when the consultations are going to be published, and then you can download them. It'd be interesting to see how long they give people to reply.
Yeah.
One of the difficulties that I've experienced over the course of my career is that all of the consultations are quite short. So you only get a matter of a few weeks to get your responses in. So you've got to marshal your thoughts pretty quickly, put them down in writing, and then send them in. So I hope that there'll be a sensible period. But yeah, it's as simple as that. If you miss the fact that the consultation has been published, well, you won't have had an opportunity to reply to it. So you do need to keep your eyes peeled.
Okay. And then we go into autumn. There's actually quite a lot in autumn. Actually, the one that sticks out for me consultation-wise is the regulation of umbrella companies, but that's a conversation for another time. And in the exploitative use of zero-hour contracts, what would be...
Well, that's the big one, isn't it? And we spent a lot of time last time talking about ending exploitative zero-hour contracts. I still think that's the wrong terminology. There's nothing in the provisions that will stop zero-hours contracts from being used, and there's a debate as to what exploitative means. So we're sort of back into that discussion. I don't know what the government are going to do around consultation here, but what they have said, they've met the mood music around this is recognition that in the agency sector, in the recruitment sector, they've got to get this right,
100%,
because most contracts are, by their very nature, 0 hours contracts. So I think there'll be a discussion around what a 0 hours contract looks like, and then of course we talked last time, didn't we, around what a guaranteed hours contract looks like.
Yeah.
What's the reference period going to be? Is it going to be, as was originally suggested, 12 weeks? So you look back over the previous 12 weeks, you average out the hours that 0 hours contract worker has worked. That then becomes the guaranteed hours contract that they're entitled to be offered. Are they going to be offered that contract by the agency or by the end user? The government's preference is that it'll be by the end user, but no obligation on the worker to say yes. So if I'm right, I think a lot of agency workers are agency workers because they want to be agency workers, not because anyone's cajoling them into it, because it gives them the flexibility that they need and want. They might have childcare responsibilities, caring responsibilities for older relatives. That sort of flexible working, I think, is the way we've been moving for the last 20, 25 years or so. So I genuinely believe that there will only be a few workers who are offered guaranteed hours contracts who will say yes. Where I think I'm interested in where the consultation goes around this is in relation to avoidance. Because since our last episode of this podcast, lots of people have said to me, okay, Paul, tell me how I avoid getting myself into a position where that worker has got to be offered that guaranteed hours contract. And what does the guaranteed hours contract look like? Can it be a contract for a fixed term? So maybe just a contract for a few weeks or a few months? Or is it a permanent contract that is terminable on notice? Will there be a minimum period, perhaps, that contract has to last for? And you can see where I'm going with that.
I was going to say, yeah.
Because if you think about it, you're going to be in a position where an employer, an end user client, is forced into offering a guaranteed hours contract in a situation where they would normally engage an agency worker. So not only will they have to enter into a direct contractual relationship with that worker themselves, but they may be doing it in circumstances that don't warrant another employee. They're being forced into offering someone a job when they may not want to offer a job to anybody.
And for me, in relation to our first podcast, that topic, once you offer the guaranteed hours, and it becomes in essence an employment contract, and we were talking about the fee element, I think a lot of recruiters, certainly temporary recruiters, have sat up and actually, don't want to say the penny's dropped, but I think the awareness now of what that, I mean, that's landscape changing.
Oh, it's absolutely huge.
Business models here that have been built over years and years and years. And it's effectively eradicated.
Yeah, it's shoehorning workers into what I'd say is a 1960s, 1970s view of what proper employment or proper jobs look like. I still think Labour suffers from this delusion that you're only in proper employment if you're working 5 days a week, 8 hours a day, and anything other than that is not proper employment. Well, you and I know that the real world is very different, and actually lots of people are in proper employment on reduced hours, part-time working, because it suits them and that's what they want and need. If this goes the way I'm worried it might, you are going to be shoehorning people into a model of employment that doesn't see the light of day these days. That's bad for employers. And it's why employers have been saying to me, Paul, is there a way around this?
Yeah.
So could we, for example, let's say we offer Mr. Smith a guaranteed hours contract after he's been a temporary worker. Can we then terminate that employment after, say, a week, wave him goodbye, and then go back to the agency and ask for another agency worker? So we keep circulating workers on almost like a 12-week rotation if it turns out to be 12 weeks. So, yeah, we do take people on. So most people will offer the guaranteed hours contract to, and they'll say, no, we don't want it, thanks, in which case we carry on as we are. Okay. But we might every so often get a curveball thrown at us where the worker we offer the guaranteed hours contract to says, oh, yeah, I'll have that, thanks very much. So they have to bring them in. Can they then dismiss them? Well, they might be able to, unless the law says there's a minimum period that contract has to last for. But even if there's not a minimum period, bear in mind, one of the things we've just talked about is unfair dismissal rights from day one.
Yeah.
So we take the person, the client, the end user client takes the worker on as a guaranteed hours contract, and from the minute that guaranteed hours contract starts, that worker's got unfair dismissal protection.
Of course.
So not only have you forced the employer to take on an employee they don't want to take on, you've then restricted the circumstances in which they can dismiss them. I mean, if that's not pro-worker, I don't know what is.
That's why I look a little bit because the pennies just dropped there for me. I keep using that terminology, but excuse my language, but I was like, shit. That's
that's a very good way of putting it, if I might say so.
Because now the responsibility is just literally, that's straight up. That's not a nice curved trajectory.
It's unusual. As you know, I've been doing this job for more than 30 years, and it's very unusual for governments to get involved directly in contractual relationships between employers and employees. They'll give safeguards. So if the parties agree to enter into a contractual arrangement or relationship, they'll safeguard the parties having made that decision. What this does is it doesn't give the ability to make the decision. It takes it away. So it forces one of the parties, if the other one says they want it, it forces the other party to say, we've got to offer you this job. We really don't want to offer you this job because we haven't got a job to offer you. Yeah. And now, I think that's a big shift. It's a big shift in policy. Arguably, it's wrong. Should governments be forcing two parties to enter into a contractual relationship when only one of them wants to?
No.
I don't think.
I don't. And if you look then at the economic elements, so like the employer's NI increase, there's a very, and okay, I'm basing this on mainstream media at the moment, and at the time of recording, I certainly have no facts aside of rumour, but talks of tax increases for something, or for workers then to be offered a guaranteed hours contract, is there also a potential mindset shift because of all the external noise that actually we see a far greater lean towards actually that security for me and that guaranteed hours contract, where historically that I don't want that, thanks very much. Does that become a possibility?
Well, to be frank, I think everything's a possibility. I got short shrift when I mentioned this to someone the other day because they thought I was being they thought it was a rather draconian view. But there is one view that says actually employers will be turned off using agency workers full stop. Now, bear with me whilst I talk that one through. If they are required to make these offers of guaranteed hours contracts to agency workers and they start being inundated with lots of yeses, yes, we'd like that, I think they'll start to say, well, what benefit are we now getting from the use of agency workers? If we get a benefit at all, it's only for that short qualifying period of 12 weeks, if that's what it turns out to be. And I suspect, as I said last time, the government will have to think about some anti-avoidance measures like they've got in the agency workers regulations. Yep. So you can't structure a series of assignments under the agency workers regulations to avoid workers getting the rights under the agency workers regulations. That's broadly what the anti-avoidance provisions do. It strikes me you've got the same risk here. You could have a client that says, I'd like to structure a series of assignments with workers that avoids any of them ever getting the 12-week rights, if it turns out to be 12 weeks. So I think the government are going to have to put anti-avoidance provisions in. And if they do that, you're fettering the employers, the end user client's discretion even further. So I do think there is a distinct possibility that some employers will say, do you know what? We're not even going to use agency workers. What we'll do is reorganise the staff we've already got so that we get some of them who are on flexible hours. So there are direct employees, so we can flex. Yeah. And so we don't need agency workers to cover those flex situations. Now that, it does sound like the worst outcome, but I think there will be some big users of agency workers who give that some thought. It's going to be harder for smaller organisations.
Yeah, because they need that flexibility.
They need that flexibility. But for big employers, 10, 15, 20, 30,000 employees plus, it might be actually easier and less problematic for them just to ditch agency workers altogether.
Labour have come across a little bit anti-agency since they've come into power, though, in my opinion. You look at the medical industry, for example, lots and lots being done about siphoning recruitment away from agencies. You explaining and articulating this. Is this just a complete lack of understanding from Labour, do you think? Or is it deliberate? Is it intentional?
I don't think any government in recent history has fully understood the nature of agency work.
I think that's the problem, isn't it?
Yeah, I think there are so many misconceptions. And I don't understand why, because it's not as if the agency lobby has been quiet. If anything, they've made
a lot of noise.
Too much noise. Yeah. And sometimes you can't distill the right messages. But look, I mean, the agency lobby has certainly made it very clear why they think these measures are potentially very negative. And the governments are saying, because it's easy to say, oh, don't worry, we will look after you. We'll make sure that we've got proper provisions in place that reflect the need to support this sector. And yet what we've currently got, subject of course to the consultation, what we've currently got is an arrangement that when you examine it may do exactly the opposite. It may ride a coach and horses through flexible working. I'm really worried about that. And
so am I.
Yeah, umbrellas, other suppliers into the sector.
Well, it's the domino effect, isn't it?
Yeah.
And, like I say, it's not a secret, is it? You speak to anyone in agency or that is in our supply chain, so to speak, and the general consensus is that Labour just don't like us, or, you say don't have an understanding of it, but I mean, what you've just said there, that's enormous.
Yeah, I'll give them the benefit of the doubt and say I think it's a lack of understanding. Okay. But I do hold true to what I said a little earlier, which is that I still think Labour governments are wedded to a version of employment that doesn't suit an increasing number of people.
Yeah, I think, and this isn't a political podcast, but I think there's a lack of understanding on many great things, to be honest, that are almost, certainly outdated, borderline relics of the past. And I think that's what a lot of the argument is now, is actually bringing everything up to a modern day.
Yeah.
Not era is the wrong word, but it should be fit for purpose in today's world.
Yeah.
But there doesn't seem to be an appetite to understand that part first.
No, I think that's right. And the other, again, I'm trying not to be political here, but it's just my objective view. I think historically trade unions have not liked the use of agency workers.
Agreed. And they certainly don't like umbrellas either.
I think that's absolutely spot on. And they say it's because there's more than average exploitation in that sector. Well, look, there may well be at some level, but my perspective on it is more around an inability on the part of unions over the years to recruit from agency worker contingents. Not many agency workers who make a living out of doing agency work are aligned to a trade union.
Yeah.
And I think it's fair to say that the trade unions hope that the agency workers regulations would result in more agency workers becoming union members. That didn't materialise. I wonder whether they're hoping that this will result in more agency workers becoming union members, because more of them are probably going to be offered guaranteed hours, and why would they not?
Yeah, because you alluded to that in the first episode. We didn't spend much time talking about it, but you did raise it then, and it's, for me personally, I think that's a bit of a scary thought, to be honest.
Yeah.
The powers that they wield, and I'm not suggesting or saying that in some instances it's not right. Me personally, I'm not a massive fan of unions. That's just Rob Sharp no one else, my own individual opinion.
Yeah, and the one thing we didn't touch on last time, and we won't be touching on it very much now, but we just need to remind ourselves that nearly half of this bill is about trade unions, trade union membership, balloting, industrial action, taking things back to the way they used to be before the legislation in the 80s and 90s, making it generally easier for unions to do what none of us like, which is take industrial action. Now, look, I don't have a view either way on that. What I'll say to you is that's a bit of this bill that not many people have focused on. You know, we've been focusing more on individual rights rather than collective rights, collective bargaining, and the ability to take industrial action. But there is a lot in this bill that will make it a lot easier.
The literally on my iPad now, the one that says you've got the autumn 2025, and it says a package of trade union measures including electronic balloting and workplace balloting, simplifying trade union recognition processes, duty to inform workers of their right to join a trade union and right of access, new rights and protections for trade union representatives will be covered by an ACAS code of practice consultation.
Yeah.
So pretty much in a nutshell.
I mean, it's the biggest paragraph on the page there, isn't it?
100%. Everything else just literally 2, 3, 4, 9 words is
look,
else.
Because of the job I do, I see a lot of the very good work that trade unions do.
Yep.
They do a lot of extremely good work, and they ought to be credited with supporting some of the most disadvantaged workers in the economy. And a lot of progressive trade unions don't take the sort of 1960s, 1970s approach to industrial relations, you know, which is handbags at 10 paces. You know, they do create and cultivate very close relationships with employers, and where they work hand in hand with employers, I think generally speaking, workers do well.
Okay.
So it's not a completely one-sided take on unions. I think they do get a raw deal in certain circumstances, and the majority of people, Rob, only see it when it goes wrong.
And that's where I come from. I see it on the news.
Yeah. So when people are striking, that's when it's gone wrong. But there are a lot of very positive relationships. And look, it perhaps in a sense ought to be easier for them to do certain things, because in the past, trade unions have been taken to the High Court and slapped with injunctions,
right,
where they've failed on one or two very small technicalities around balloting.
Okay.
Yeah. So they've wanted to strike, or they've wanted to take industrial action, technical defaults or failures, and the employer's gone to the High Court and got an injunction to stop them taking any further action. There is an argument that making it a little bit more transparent and a little bit easier is probably better for everybody.
Right.
And that's really as far as I'll go. I'm trying to rebalance the conversation slightly.
And sorry, I probably put you in a bit of an unwanted position.
Not
there.
at all.
Look, I think we could probably have an episode entirely on guaranteed hours and stuff like that. And I do think actually after Royal Assent, episode 3, I think that will probably be in much, much greater detail and in terms of what it potentially looks like, or certainly the direction that it looks like it may be going in.
And I suspect we'll have some of these consultations that we're talking about now will have the document.
Right.
And possibly, depending on when we schedule the next one, we might have some responses. So I think we will have a clearer direction of travel on some of these big topics.
Okay.
Yeah.
So again, I mean, you've got, what about fire and rehire? Do you think that's high on the agenda, or?
Yeah, I mean, again, it's the terminology is wrong. It's colloquially called fire and rehire. In reality, what the government are saying is that if you want to change someone's contract of employment as an employer, and the employee says no, if you then dismiss them, then that dismissal will be automatically unfair.
Right.
So it's been phrased as fire and rehire. In reality, it's much wider than that. So I think our problem as employment lawyers is getting to grips with just how wide this could be, and making sure that when we're advising clients on changing terms and conditions, that it's done in a way where the client fully understands what the potential ramifications are. I don't think we're going to see a situation, because there have been some developments on this, I don't think we're going to see a situation where every small minor change to a contract of employment, if it's turned down by the employee, is going to result in an automatically unfair dismissal claim. There's an element of realism, I think, which the government are now building into this proposal. But yeah, I mean, fire and rehire, I hate to slide into the trap of calling it fire and rehire, because as I've said, it's wider than that. I don't think it's as wide as people were fearing when it was first announced.
That's a good thing, obviously.
Yeah.
I think probably that's the core topics in terms of the consultations that I think recruitment agencies, for example, certainly with conversations I've had, is the immediate focus. So obviously moving forward onto, I think it would be prudent that we just look at what's coming in 2026 as opposed to going beyond that. So the measures that we know are going to come into effect in 2026, what stands out for you on that?
Well, we've got this huge body called the Fair Work Agency that we know a bit about. So we know what functions it's going to discharge that are currently discharged by other bodies. So the GLAA, HMRC around national minimum wage, and the Employment Agency Standards Inspectorate. It'll have a much wider remit than just those things. And my worry, which I expressed on the last edition, was whether it was going to be properly funded. Yeah. Because it's fine to say we're going to have this humongous body that's in charge of all these things. If you've only got 5 people, sorry, I'm exaggerating there. If you've only got a handful of people and minimal resources, it's not going to it's going to be complete damn squib. So everybody's looking at it and saying, "Oh, isn't this a great idea?" Conceptually, there's no doubt it's a great idea to have all of that under one roof with information sharing across those 3 bodies. Is going to be exceptionally helpful for enforcement. Some of the powers around what the Fair Work Agency will be able to do, I still think are coming across as a bit draconian. So, for example, being able to bring an employment tribunal claim for someone who doesn't want to bring an employment tribunal claim. Yep. It's been interesting to see how that washes through. But yeah, that will be brought into being in early 2026. I think there's going to have to be a lot more meat on that bone before we can give a view as to whether it's going to do what it says on the tin.
I agree. I got all the emails to join them. I think it's the first week of September last week, and I was going through them thinking, bloody hell, you're absolutely right. Yeah. And you know what? I was reading the emails thinking, I like that. But it is behind the scenes where you think, well, it's all well, and the optics look good, but let's see what really is the meat on the bones, as you quite rightly say.
And we're told that there's no money.
Exactly.
So, we've got a new body that's created that will need some resources. Well, the obvious question is, where are those resources going to come from?
Yeah. And also for the department's Employment Agency Standards Inspectorate, HMRC, obviously the National Minimum Wage element, and the GLAA, in their own individual, when they were individual entities, they're enormous bodies when you look at what they actually do as well. So they need funding, and not just a couple of shillings here or there. Like, this needs to be properly, well, let's put it this way. If you want to do it right, it needs to be funded right. Otherwise, is it really going to have and carry out what it's set up to do?
Well, I think that's absolutely right. And going back to the point I've made, if they follow through with the Fair Work Agency can bring a tribunal claim on behalf of someone who doesn't want to bring it, well, bringing tribunal claims is not a cheap exercise.
Yeah, absolutely.
And you're going to need to have someone that, are they going to do it internally?
Mm-hmm.
Are they going to outsource it to lawyers? Who's going to pay the cost of it? So all of that, I think, is going to have to be considered. And I don't know, I haven't seen too much which gives me an enormous amount of comfort that this new body is going to have resources following it. So my concern is that it will turn out to be a bit of a damp squib. And if it is, my worry then is that things that are being very adequately dealt with currently, for example, like by the GLAA, where organisations are being licensed, they're having licenses revoked if they don't meet the licensing standards. You might see some of those just fall through the gaps.
Yeah. So
actually, the GLAA that's there to look after workers who are being exploited, the Fair Work Agency doesn't serve that purpose anymore. So to me, that's a real problem. I mean, look, I don't want to be a cup half empty.
Yeah.
I think it's a good thing that we're moving towards a single enforcement body. I'm just worried about the resourcing of it.
Well, it's the proof's in the pudding, isn't it, unfortunately? And that's with everything. And whether we like that or loathe that, that's just the reality. Yeah. So, do you know what? I think let's, as opposed to me being a harbinger of doom, which I normally am with anything government related, let's give them some time to hopefully get it right. And like you say, I'm with you. I think a single enforcement body is absolutely the right way to go. Okay, anything else on what you think recruiters should be aware of?
Well, if we're still around April, so if we're following the roadmap, April, we've got Fair Work Agency, we think, or at least that's what the roadmap suggests. The other big change in April is going to be statutory sick pay.
I thought you were going to say that.
And we talked a lot about this last time, basically easier for statutory sick pay to be claimed, a whole group of workers being brought into statutory sick pay coverage that don't currently have it. And importantly, I think this is the biggest change and one that will disproportionately affect agencies, it seems to me, is not having the 3 waiting days. So statutory sick pay being an entitlement from day one.
Yep.
And that cost is going to have to be picked up by someone, it seems to me. And again, conceptually, policy-wise, do you agree with more people being able to claim statutory sick pay? It's probably not a bad thing. I'm with the government on that. I've never quite understood why so many people were excluded from it in the first place. My worry, because I see a lot of inquiries and hear a lot of inquiries from clients on this, is abolishing the 3 waiting days.
Yeah, I agree.
To my mind, in certain circumstances, in certain sectors, it could be a recipe for people swinging the lead.
I think that it will be open to abuse categorically.
Yeah.
And especially for umbrella companies. Timing's obviously is always good. We had one this morning. This is a guy who historically, work a week and then he's sick for 3. Work a week, sick for 3. And constantly and contractually we have to pay that. And there are people who are acute enough to actually understand that you can play the system.
Yeah.
So there will be from an employer, certainly for us as umbrella companies, it is something that we're going to have to be acutely aware of.
Yeah, I think one thing I've always thought about statutory sick pay, it's not set at a particularly high level, and there doesn't appear to be an appetite to change that. I think the minute you start to move statutory sick pay towards average weekly pay, the more likely you're going to have people who decide, do you know what, this week I'm going to be sick.
100%.
So I think there's still a bit of a disincentive because the amount you get paid is still relatively small. And that's why I say I think it'll disproportionately affect industries that don't pay well.
So the lower paid.
Yeah.
Yeah, and I mean, it's hard to argue, though, to a certain degree, because if you get paid the same amount, hypothetically, when you're being at home and you're not asked to provide any, do you know what I mean? Like any proof of that.
Yeah.
I don't have travel costs.
Yeah.
I don't have all the other costs that are associated that day.
Yeah.
And I think that's where the balance needs to be right.
Yeah, and again, I don't have the numbers, but this is only statutory sick pay we're talking about here.
Yeah.
Lots of employees get contractual sick pay, and these changes won't affect that. Save that. The clause in the contract normally says, if we pay you contractual sick pay, what we pay you includes any entitlement that you might have to statutory sick pay. So there needs to be some recalculations done around all of that.
Do you think you'd see a lot of recruitment agencies then hypothetically change their contracts to go to a contractual sick pay agreement?
Well, I mean, it's possible. I think the one thing before any agencies do anything about any of this, the one thing they ought to be doing, and some of them are already doing it, but maybe not as many as I hoped, is having a dialogue with their client.
Right.
Because a lot of clients haven't really given much thought to how this affects their relationship with agencies. They might have given an enormous amount of thought to how it affects their relationship with their own staff. But if you've got a client who's heavily reliant, if you're an agency, you've got a client who's heavily reliant on you for agency labour, you really need to be talking to them about what they think this looks like moving forwards. Because otherwise, you're going to be taking decisions about your business in a vacuum. And that's really dangerous.
And I think a lot of the first episode there was a lot of your guidance was to have conversations with your clients, not just about statutory sick pay. The guaranteed hours, for example, was another thing. And I think that's the part now where anyone listening, I think, we're talking about April, we're getting into the 6-month window. So October to April, and the next time you blink, it's April.
Well, it's unfortunate, isn't it? Because you've also got umbrella tax changes.
Yes.
At exactly the same time.
Yeah.
So in that sense, it's a bit of a double whammy for you. So, I mean, if it helps, we are talking to agency clients, and we've already done some events with agency clients where they have organised a webinar or a seminar with their own clients, so end users.
Yeah.
We've sat in a room and we've told them what all this is about. And I'm amazed that some of them have said to me afterwards, we didn't know any of that. I sort of asked myself, well, where have you been hiding for the last 6 months?
But you know what? I and it's a fair point that you make, but economically it's been so hard that, and I speak to my recruitment clients all the time. They are head down and just grafting. And, yes, they need to understand and they need to know what's coming. But I sort of am empathetic to why it's sort of gone over one's head.
Yeah.
Is because it's been so hard.
Yeah.
But anyone who's just listened to that, obviously you have a ready-made solution there with Paul, his team. If you want to speak to clients, I absolutely implore you to do it now. The clock is ticking. And like we say, I mean, these are coming in April. So we're pretty much or just halfway through the middle of August as we record this. So it'll be here before we know it. So again, please speak to Paul. I'm just conscious of our time, Paul, and
well, no, I can rattle through the rest because we've got.
Well, I was going to say, and also because obviously once Royal Assent has been reached, what we'll do is we'll do another in-depth one, which I think we'll spend some serious time on. This was more just to give everyone a bit of a sanity check. But I'll hand over to you.
Yeah, I was just going to say in relation to the rest of the published roadmap. So in October of next year, we're going to be looking at extending tribunal time limits. So at the moment, most claims are going to be brought within 3 months. That is going to be extended to 6 months, and we talked about the pros and cons of that last time. I'm not sure that that's really necessary, but the government seems to think it is. The fire and rehire rules, again, I've fallen into the trap of calling it fire and rehire. Changes to contractual terms and dismissal rules. We're looking at the roadmap suggesting, again, October next year for that. And I'm just looking at my list down here. One that's sort of gone under the radar a little bit. There's going to be some changes to the law around sexual harassment.
Yes.
So we did have some changes last year. The government wanted to go further. So that was a Conservative Party amendment to the law. The government are pushing a little bit further and raising the bar for employers. So instead of taking just reasonable steps to prevent sexual harassment, the obligation will be to take all reasonable steps. Now, it's a very small word of only 3 letters, but that makes an enormous difference to the legal interpretation of that obligation.
I had an enormous conversation actually with another lawyer specifically around sexual harassment, and there was lots of the word preventable, preventing. Again, I think that is certainly to give it the merit that it's due. And 2 gentlemen sitting here talking about it for 2 minutes. I don't want to do that. I think we should look at that in its entirety with respect and properly.
Yeah. It's a big change.
Yeah,
it's a big change. And then roadmap wise, we're then into 2027. We touched last time on regulating umbrellas.
Yes.
2 elements to regulation. One, the tax changes, which we already know about because that's been published. That's with effect from April of next year. Bringing umbrellas into the definition of an employment business for the purposes of the Employment Agencies Act and the conduct regulations. That was the plan. That plan is going to materialise, but it's going to be in 2027. Yeah.
It's consultations.
Consultations first, yeah. And then, I mean, I don't think that's a particularly big change.
Yeah.
I don't think it's technically too difficult either.
Yeah. Agreed.
But for some reason, the government want to leave it until 2027. And then the big one that we've already talked about, but we didn't talk about timing, is unfair dismissal day one rights. Again, 2027, they are suggesting.
That caveat, though, I think for me personally is because of the complexities of it. I think you look at the umbrella regulation, for example, that isn't difficult. I just think that that's just been left to the end. I think actually with the unfair dismissal, that's been left to 2027 because I think they understand the enormity of it, the importance of it, and also the complexity. So I again, credit where credit's due. I'm actually pretty pleased that they're doing that. My hope now is that they're looking at that properly and from all angles, and actually are having conversations with people like yourself, businesses, to actually ensure that it's fair for all sides.
My one fear, because bear in mind this is just a roadmap, there's nothing legal about this document. My one fear is that if I'm wrong about the Lord's Amendment and the government do decide to bring in just a reduced qualification period rather than eliminating it completely, they might bring that forward from 2027. Because in reality, all you're doing is saying it's not 2 years anymore, it's 12 months or 6 months. Nothing else will really change. There won't be any need for a statutory probationary period in those circumstances. That change, I think, could happen quite quickly. So my worry is if we do get into a we'll take the Lord's Amendment route, we might end up with an earlier than 2027 change to qualifying period, but we'll see.
I was exactly. And so so sort of bringing this episode to a close. If I'm a recruitment agency, what's your advice to me now? Then given where we were, where we currently are, going forward, what's your best approach for anyone listening?
It's the word relax doesn't figure. I mean, I know you said you feel as though some of the pressure's been lifted, rightly, because the time period. One thing we were really worried about last time we spoke was we didn't have a roadmap.
Yeah, we
were guessing when some of these provisions were going to come in. So again, to give them credit, they've paused for reflection, but they've also given us a broad time frame. And I think that's really good. So rather than relax, I think more of a structured approach now to getting to grips with what some of these provisions mean. You can do that. It doesn't have to be scattergun anymore. You can time your approach in line with the roadmap. But it's this. My overriding message is the same as last time. You can't deal with any of this unless your clients are educated and unless they and you are singing from the same hymn sheet. So get out and talk to your clients. And goodness, I like nothing more than going out and talking to clients, because the relationship I have with my clients is a very personal one. And you can maintain and enhance that relationship by having a conversation. So that's the first tick in the box. The second tick in the box is you're also giving them some added value by saying, look, we value this relationship moving forwards. We want it to work, but we're letting you know that there are some really big changes on the horizon. Nothing to worry about. We can work with you to make sure that you still get the flexible supplies that you're looking for, and that you don't create any legal problems. So I would say, overriding message, talk to, educate, and work with clients.
It's readiness, isn't it? That is it.
Yep.
Paul, do you know what? I love this. I've got to be honest. This is the second time.
It's getting too comfortable, this, isn't it?
I've got to be. I don't know whether I came across well on camera, but I'm so relaxed. But just listening to you and the education I get from sitting across you, honestly, I can't speak highly enough.
I've thoroughly enjoyed it again.
Yeah.
And next time we'll do it with a beer rather than with a glass of water.
100%. Well, I think next time we might need a beer as well.
Right.
It's a pretty big one. But just listen on behalf of myself, our listeners, thank you very much for coming in again, and I can't wait till the next one.
Thank you.
That's it. So thank you very much for tuning in. Thanks for listening. If you do want to follow Orca Pods, please subscribe to either our YouTube channel, our Apple or Spotify, and very much look forward to seeing you next time. Many thanks. Goodbye.